You were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is it looks like you're on probation for a felony retaliation case, which is now set at no bond. So we're going to do probable cause here today, if there is enough.
Let's pause for a second. Felony probation and a DWI second offense? That's stacking charges like it's Jenga, and this tower is shaking. Judges don't play around when you violate probation while racking up new offenses. Think this is a bond-worthy case? Sound off in the comments below.
I'm sorry.
You're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide you a lawyer today. For now, we'll do probable cause on DWS. You're facing up to a year in jail and or a $4,000 fine.
The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and the filter right his working day. HGN 606, walk and turn 508, and the defendant refused to do the one-lane stand.
2 breathalyzer readings .139 and .146. That's nearly double the legal limit. Translation: toastier than a Texas barbecue brisket. But here's a twist: she consented to the breath test. Smart move or a missed legal opportunity? Defense attorneys, weigh in.
DIC was red, his breath was sniffed.
Whoa, did you catch that breathalyzer result? A staggering 0.139, way over the legal limit. And .046 on the second reading? Double trouble. What do you think? Should refusal to take field sobriety tests carry harsher penalties, or is it a smart legal move? Let me know in the comments.
The results were .139 and .146.
Alright, have you seen whether she has a valid Texas driver's license? Alright, Ms. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to drive. It is a condition of your bond, and you will be signing an affidavit with me for promising me you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody. If you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in the state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. Do you understand? No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk to this person to figure out how we go forward.
.40 to .50 racers. This isn't Fast and Furious. It's fast and felonious. The fact that officers had to tail this group across the city shows just how widespread and dangerous street racing has become. Should these be treated as misdemeanors or felonies? You decide.
All right, come on, we'll have you sign this and then we'll have you sign your conditions. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On December 27, 2024, the officer was assigned to a traffic crimes task force, followed a group of 40 to 50 racers from 2400 blocks in Basin to San Luis. The officer
40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour. And both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. Traffic stop was conducted, and the officer made contact with the driver and the defendant. He was the sole occupant.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
Not eligible.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by 6 months in jail and a $500 fine. Do you understand? Not drive. Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a receipt, and we're going to get you out of here. When you come back, you have a lawyer. Yeah, can you file no racing, reckless driving, and all that? Yes, Vic. So you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So.
On December 28, 2024, the officer was dispatched to an apartment in Harris County, Texas in regard to a single vehicle accident.
Okay, let's recap. He crashes into a mailbox, ditches the car, leaves his ID and utility bill inside, walks home, and takes a nap. The detective work basically solved itself. But here's a real legal nugget. The officer entered under the community caretaking doctrine. Do you think that was justified, or should a warrant have been required?
That hit the mailbox of a resident. The officer observed that a defendant's motor vehicle with heavy front end damage did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill, came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact with the residents, one to make sure the motor vehicle was not stolen and one to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in a...
Whoa.
It was because they had... Whoa. Yes, the vehicle was damaged and he wanted to make sure the driver was... He announced himself and went into the residence. After the door was open. And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said, car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 or 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle...
Okay, hold up. The guy walks away from a car crash, leaves behind his ID and utility bill, and goes to sleep like it's a normal Tuesday? And then the officer strolls into his house under the community caretaking doctrine? This is like a real-life episode of Law and Order, Sleepy Edition. Would you consider that legal entry or overreach?
Was it. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So, are you telling me that he did stay though?
No. What happened, Your Honor, is that he struck the mailbox of the apartment, and the defendant said that he called his insurance, no one came to the scene, so he walked home. And the officer, when he arrived, saw that...
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stayed with. Then after that, he walked home because no one arrived. And then that's when the officer arrived and saw his empty vehicle damaged. Then he found the utility bill and ID.
I have so many questions. Let's do this. I'm going to appoint you a lawyer, or you have a lawyer, right?
An unlicensed driver, weed in the jeans, and an unholstered AR-15 pistol in the front seat? That's not a traffic stop, that's a criminal jackpot. Bonus twist. He says it's for protection because his brother is a famous rapper. But legally speaking, being related to fame doesn't equal self-defense. Thoughts?
I'm going to hold off on finding probable cause for the moment. Let me wait for your lawyer to get here. We'll revisit PC and here momentarily. Just go ahead and take a seat for me if you don't mind in the jury box. Yeah? Let's wait for your lawyer to get here and then we'll be short. Sir, you were charged with unlawful carrying of a weapon and you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On December 27, 2024, the officer observed the defendant's vehicle failed to maintain a single lane and veering over to the left lane on 3 separate occasions. A traffic stop wasn't conducted. and the officer made contact with the defendant, the driver of the vehicle. The defendant advised he was unlicensed and that the motor vehicle was not insured. The officer observed a strong odor of marijuana emitting from the passenger area of the vehicle, and the defendant voluntarily produced a partially burnt marijuana cigarette and stated it was the source of the smell. The officer conducted a search for the defendant's identifying information, which yielded an open felony warrant for continuous violence, and a search of the defendant's left jean pocket yielded a clear plastic baggie containing a green leafy substance. The substance was identified as marijuana based on human experience. The defendant's motor vehicle was searched incident to arrest and yielded an unholstered AR-15 pistol in the front.
AR-15?
AR-15 pistol, Your Honor. And the defendant acknowledged ownership of the firearm and stated he used it for protection since his brother is a famous rapper.
Find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or prescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. Do you understand? You do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in this life. I don't care where you got to go. I don't care what you got to do. If you don't have a license and liability insurance, do not drive. Do you understand? How old are you, sir? What do you do for a living? Why? I don't work. Oh, how do you support yourself? How do you support yourself?
I'm really supporting me out. I ain't go out looking for a job.
It's time. I will provide you a lawyer today, but it's time to get a job, a full-time job. When you have too much time on your hands, you become self-destructive. Not here. Do you understand? All right. Do you mind doing an application, please? I need you to fill out an application for me. I'm going to have you sign a receipt of Victoria. I'm going to have you meet with Fleischer for your bond conditions, and then we're going to get you on the right track, Mr. Galdo. Come on. Good morning, ma'am. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. The complainant and the defendant are in a dating relationship for having 6 years, and on December 28, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas. The officer met with the complainant who stated he was assaulted by the defendant at around midnight that morning. The complainant said he and the defendant had been in a comedy club and the defendant was drinking. An argument ensued and the complainant began gathering his belongings, and the defendant punched the complainant in the face with her left arm, making contact with the corner of his face. The complainant said the defendant also slapped him with an open fist on his right cheek twice, causing pain.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with the case. Do we know whether he wants to have contact or not? You guys reached out to
The
him?
report detected this morning.
Because I don't know what this person wants, I'm ordering you not to have
I have
contact.
a contact order, no contact.
Stop. Just don't say anything. I'm just telling you what the expectation is so you know. Because if you violate these conditions or if you take a new case, I'm going to revoke the bond. We'll put you in jail. No more PR bonds. So no contact, no weapons. There is a protective order that has been issued in this case. Get to know it. If you violate the protective order, you can file additional charges against you. You understand? So what we're going to do now is I'm just going to be signing a receipt with Victoria. We'll have you take jury, wait for your lawyer to get here.
He's not gonna come, they've already contacted you guys and let you know he's out of town and he'll be back on the night. He said I just needed to come and sign my bond conditions.
Okay.
It's Maverick Ray.
Contact the weapons. All right. So what we'll have you do is we'll have just take a seat. We'll have you sign a reset, and I don't know. Perhaps we'll. Did you hear from Maverick at all?
They did try to reset the bond conditions.
Did they give you a good date?
Back on the night.
Pretty much out. They want to
Got it. Okay. So we'll have you sign a reset, and we'll just have you take a picture.
Yeah.
Please. Hey, how are you, Mr. Stewart? It's good.
How's your name?
Great. We did PC on your case, which did stand. What's your guys' name?
His last name is Allen, Your Honor.
I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So, refresh my memory, what happened?
So in Alan's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green.
He had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there are other vehicles around the vehicle before the driver jerked back to the lane. We went into the shoulder with there were other vehicles.
Right.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed the Silverado drift into the shoulder with other vehicles around it. If it's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of, the safety of anybody else out there on the roadway. Shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to stop it. This is insufficient information. And I would argue that there's not valid probable cause on this.
I think he has a valid point where, perhaps he's... Well, I mean, I don't want to speculate.
This is where things get spicy. The defense is arguing there's no probable cause for a stop just because the car drifted. The statute says the movement must be unsafe, but was it? Here, the officer says, yes, but no direct danger was detailed. So, is that a valid stop under Texas law? Courtroom debates don't get better than this.
Speculate, and you're saying, well, maybe he did it because of this, but right. I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know.
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for stop.
Right, but you got to articulate facts as well, right? So, according to statute,